I just got a message from Matt Rains that on the 1:30, he wants to come in person with his client on Cooley.
Okay. Mr. Byers, you want to come on up? So this is in the matter of the people of the state of Michigan versus me, Jonathan Byers, file number 23-21531FH. This matter was set for probation violation hearing this morning at 8 a.m. Mr. Byers was here right at 8 a.m. and it is now 8:08. So Mr. Byers, let's see, we have adjourned this out quite a bit for you to pay restitution. And I show that you didn't have a court-appointed attorney.
No, I didn't want one.
Okay, do you want one today?
No.
Okay, Mr. Byers, I believe the last time we were here, you stated that you would make a payment by today. Were you able to do so?
Yeah, I've paid $1,000 since last time I came to court.
Okay, when did you pay that?
It was $600. I paid like 2 or 3 weeks ago.
You paid 600?
Yes, ma'am.
When did you pay 1,000?
I had paid, when I came to court last time, I paid 400 and then I paid 600 like a couple weeks ago.
So you're still 1152 then, right?
Yes, ma'am. And last time I was in court, you said that you would waive $450.
They did that already. Let me see here. So,
The 450 never came off because I've only paid 1,000 since then. It was 2,100. Now it's 1,100.
okay, so hold on. So at the time, based on that rate, so you still have a balance then. So when would you be able to pay that? You got income taxes coming?
Yes, I do.
Okay,
It
so,
should be, I mean, if the 450 does come off, I could probably, I'll be able to pay a lot sooner.
I'm showing that, let me see here, he deducted, I'm looking for dates on this. So originally, $2,961 were ordered,
Yes,
was
ma'am.
ordered, and so Becky, are you able to pull up Mr. Byers and see what the balance owed is?
Yes, Judge, it does show 1,151 and 66 cents. And I don't think that attorney fee was waived, but I'm not sure if I'm reading this right.
Say that again?
I don't know if that attorney fee was taken off this, but I don't know if I'm reading this right or not. I'll have to check. With the
Okay,
clerk.
I'm gonna go look real quick.
Okay.
Okay, I'll be right back.
Okay.
You're good. Just like that. Mr. We're back on the record. So Mr. Byers, we did call over to the clerk's office. Your payment shows that it was made. They took off the court-appointed attorney fees, but the remaining balance is still $1,151.66. So I'm gonna adjourn this out to that payment, and feel free to go down to the clerk's office and ask them to show that to you.
When I paid the $600, they did give me a statement, and it showed that when I had court last time, it showed that I had owed 2158 or something like that. And then I paid the 400 and 600 since then, and it still shows 1158.
Well, if it showed 2158 and you paid 1,000, that is 11.
Right, but then that would mean that the 450 of the lawyer fees never came along.
We show that they're off, and that's still the balance. So feel free to go down there and ask them to explain it to you, but I just did call the clerk's office and she's saying, yes, I did take that off.
Okay.
So go down there, ask them to look at it and explain it to you. I mean, that's what they explained to me. So
I just thought I only owed $750 or something.
go talk to them, and then I'm gonna set this out 60 days, okay? And then whatever the balance is, I want it paid by then. So Miss Adams, I need a date out 60 days. And a notice, please.
You want it on a Friday again, Judge, or
Sure.
we could do Friday, May 16th at 8:15.
All right, and if I could get a notice of hearing from Mr. Byers.
Okay.
So have a seat, and we'll get that notice, and then go on down to the clerk's office. They'll go through it with you. They're super helpful.
Okay.
No, sit right there. So just right there. Yeah. Just go down there and talk to them. Okay.
Thank you.
Thank you.
Have a great day.
You too. Mr. Bowman, can you hear me?
Yes,
Good morning, Mr. Bowman. So we're waiting for your attorney. He usually goes to the other courtroom first. So he'll be back with us shortly. So I'm gonna pop you back in the waiting room, and then when he gets here, I'll bring you back in, okay?
okay, thank you.
All right, thank you, Mr. Bowman. All right, so I am going to recess. Somebody gets- morning.
Please rise for court style session.
I'm sorry, I didn't see you pop in. You
Sorry.
snuck in quietly. Do you have Mr. Bowman, right? Do you have Joshua Rowley?
Yeah.
You do?
Yeah.
Okay.
I've been contacted him this morning.
He has not gotten his phone.
He hasn't gotten his ID and he hasn't found a ride from Kalamazoo to here.
We're gonna find him a ride. Okay. So I'll call that case first. All right, this is in the matter of the people of the state of Michigan versus Joshua Dexter Rowley, file number 24-21911FH and 24-21957FH. I have Michael Dagger Margosian appearing on behalf of Mr. Rowley. This matter was set for hearing this morning at 8:15. It is now 8:50 a.m. Mr. Rowley is neither present in the courtroom or present via Zoom. He was given notice of today's hearing verbally on the record, and also a mailing was sent out to notify him of that. But he was given notice. Oh, no, actually, he was given personal service on February 21st of 25. Mr. Rowley is not present. Mr. Dagger Margosian, do you know where Mr. Rowley is?
Your Honor, as I was saying off record a little bit ago, I have been communicating with him this morning. He lives in Kalamazoo. He has not been able to find a ride to get here. Unfortunately, money is tight, and that is part of the reason why he's having these issues. He has been required by this court to get his fingerprints. That hasn't happened. It's because he hasn't gotten his ID. We've gone back and forth on this. So that's what I can provide.
So this matter was set for sentencing on January 10th, January 24th, February 7th, February 21st, and over to today. Even during, prior to the plea, he was ordered and requested several times to get his fingerprints done. He's failed to appear. Mr. Dagger Margosian, I appreciate that you've gone above and beyond with all your efforts to accommodate the court's requirements and also work with your client. I am going to issue a bench warrant for his arrest for failure to appear. And if he's picked up, as soon as we get his fingerprints, we can discuss a bond, all right? I'm gonna set bond in the amount of 5,000 cash on each file. So I do have Mr. Bowman. Do you need to talk to him today? No. I'm gonna let Mr. Bowman in. Right, Mr. Bowman, thank you for your patience this morning. Mr. Dagger Margosian has just finished up in the other court. So this is in the matter of the people of the state of Michigan versus Manuel Bowman III, file number 24-22085FH. And I actually need to find out where I don't have a probation officer. So let me see if I can get somebody.
Judge,
Yeah.
Chris Jones was finishing up with Old Saver and was gonna be over.
Okay. So, all right, so, I do have a pre-sentence report. You received a copy of that, Mr. Dagger Margosian?
Yes, ma'am.
All right, Mr. Bowman, have you had a chance to review the pre-sentence report with your attorney?
Yeah,
Are you satisfied with your attorney and the advice that he has given you?
yes,
Mr. Dagger Margosian, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
Your Honor, there are a few things, and I don't know if we want to.
Yeah, we gotta wait for Mr. Jones. Let me see what's going on. Let me check I follow Judge Olsaver on YouTube, so I'm gonna go check out his page right now. Let's see, Chris Jones is still there. Let's see. Yeah, Chris is there finishing up sentencing. So we're gonna give him just a minute. I see where they're at. So hold on a second. Oh, he just left. So Chris should be popping in. All right. No, he's still in Judge Olsaver's. Let's see. No, he's still in Judge Olsaver's. Nope, now he's gone. So I think he's coming in ours. And here he is. Great. All right. All right. Good morning, Mr. Jones.
Good morning.
So Mr. Dagger Margosian had a few things he wished to explain or challenge regarding the information in the pre-sentence report on Mr. Bowman.
Okay.
All right, Mr. Dagger Margosian.
Your Honor, some of these are just minor, but I did want to just make sure the PSI was correct. In the under the evaluation and plan on page 1. Spot it. The third paragraph says Mr. Bowman is single and claims paternity of 4 children, in which he pays $650. That should be $750 from what Mr. Bowman tells me.
So Mr. Jones, Mr. Bowman advised his attorney that he's ordered to pay $750 a month in child support.
I'm fine to change it. That's the information that was provided to me by him and his family at the interview.
Okay, thank you. So Mr. Bowman, obviously you can provide that verification to Mr. Jones too. All right,
Okay,
Just the next one, same page, same paragraph, the last sentence reads, the offender consuming alcohol and smoking THC, but has not in approximately 3 weeks from the interview. Mr. Bowman states to me that that should be 2 to 3 years, not weeks.
okay. So Mr. Jones, Mr. Bowman's advising it's been 2 to 3 years since he's consumed alcohol and marijuana?
That's the information provided.
Okay,
Again, that's the information provided to me at the interview, Judge. If you want to change it, I have no objection to it.
okay, we'll change that to 2 to 3 years. Anything else, Mr. Dagger Margosian?
Your Honor, the only, well, I guess it's one of the conditions. I'm happy to address that now.
Well, I will say that there was a Killebrew agreement struck between the prosecutor's office and your attorney, Mr. Bowman, that there would be no upfront jail at sentencing. The court will, of course, honor that as it's an agreement with the prosecutor's office, but it's a condition of probation. Wait a minute. Okay. All right. The probation, is there anything else other than that?
Nothing in the body of the report, Your Honor.
All right. So the probation department, does the pre-sentence report disclose any prior convictions in which there exists any known constitutional defect?
None to my knowledge this time.
The probation department calculated the minimum sentencing guidelines to be 0 to 11 months. Do you agree with that computation of guidelines?
Okay.
Okay, so now I'll give you an opportunity, Mr. Dagger Margosian. Is there anything you'd like to say on behalf of your client before the court passes sentence?
Your Honor, 3 things. Number 1, the court already highlighted one of them, the the sentencing agreement for no upfront jail on this matter. So I would just ask the court to obviously honor that. Number two, the condition 6, which is you must not possess or controlled substance. You must not use or possess controlled substances or drug paraphernalia unless prescribed to you by a licensed physician, or be with anyone you know to possess these items. He does live with his mom. His mom does use medically prescribed marijuana, so I just asked the court for that specific carve out.
All right, so he can't use or possess any illegal controlled substances. And I will change that, Mr. Jones, to say illegal controlled substances, or be with anyone. So unfortunately, the state of Michigan has deemed that marijuana is legal. And if she has a medical license, obviously she has the right to do that. All right.
And then lastly, Your Honor, I don't remember what number it was, but in my notes, there was a requirement for SORA or SORA adjacent classes. I had objected to that. Obviously, this conviction necessarily does not require that. And based on the, I'm not here to litigate the case. Obviously, based on the strengths and weaknesses of the case, this is the result that the prosecutor in our office came up with. So I'd ask the court to, I don't see a reason why under an attempted FA, sex offense registry classes would be required. So I'd object to that at this time.
Okay. Anything else?
No, thank you.
Mr. Bowman, is there anything you'd like to say on your own behalf?
No, thank you, Judge.
All right. So in determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, the report and recommendation of the probation department, as well as what has been set upon the record at this hearing, the criteria and reasons for the sentence, the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, the potential for reformation, vindication for the law, and protection of society. It's a sentence of the court. You'll be placed on probation for a period of 3 years. You are to pay a $750 court cost, $130 crime victim rights fee. If you have to pay the DNA fee, it's $60. I don't know the date of your last felony, so you may not be responsible for that. $68 in state costs. There is a $30 per month supervision fee, $60 if we have to order an electronic tether. We'll give you credit for the 5 days you've already served in jail. During that term of probation, you're not to violate any criminal laws of any unit of government, not to leave the state without consent of the court. You're not to use or possess alcoholic beverages or other intoxicants. You can't hang out at a bar. Like you can go to Jerry's Pub for dinner, but when it converts to after dinner hour and bar time, you would have to leave. Do you understand?
Yes.
Okay. Once they stop serving dinner, you have to leave an establishment. You must comply with all alcohol and drug testing as directed by the field agent, not submit any fraudulent or adulterated samples. You can't use or possess any illegal controlled substances or drug paraphernalia unless prescribed by a licensed physician, or be with anyone known to possess those items. So if you have a buddy that, which I'm sure you don't, that uses methamphetamine or something like that, you can't hang out with them when they're using. If ordered, you must complete a mental health, domestic violence, battery intervention, or any other recommended treatment. Report monthly or bi-monthly as required. You must complete, notify the probation officer immediately of any change of address or employment status. You must submit to a search of your person and property, including but not limited to your vehicle, your residence, your computer, without need of a warrant if they have reasonable cause to believe that you violated the conditions of your probation, and report any arrest, police contact, loss of employment, or change of residence to the field agent within 24 hours. So, Mr. Bowman, with regard to your attorney's objection to sex offender treatment, you do have prior convictions for criminal sexual conduct. In 2001, you pled to, oh, you had, okay, so in 2001, you had a CSC that was dismissed. We don't have that one. In 2002, you pled to assault with intent to commit criminal sexual conduct, second degree. You did violate probation and were discharged unsuccessfully. On another file, you pled to assault with intent to commit CSC second degree in November. So 2 offenses occurred in 2002. Again, you violated your probation and you were discharged unsuccessfully. And let's see. You had several other counts that were dismissed at the time of sentencing of CSC. So I think it's entirely reasonable based on the nature of these charges, even with the plea agreement that was struck between the prosecutor's office and your attorney, that if you are ordered to enter and complete sex offender treatment, it would only be to your benefit to make sure there are no further offenses. So you must comply with that if ordered by Mr. Jones. So Mr. Bowman, we are going to mail to your house an envelope, and in that envelope will be a self-addressed stamped envelope and 3 copies of your notice of right to appellate review. It'll be marked for you to initial and date 1 copy when you received it, and then I need you to fold that back up and put it into the self-addressed envelope we provided to you that was in that envelope, and put it in your mailbox to come back to us, okay? The other 2 copies are for you, and if you wish to appeal your sentence, you would fill out the information on the form and mail it to the address listed on the form within 42 days, all right?
Okay.
And if you don't have access to a mailbox, you can just bring it when you report to Mr. Jones and drop it off at the clerk's office, okay?
Okay.
All right, do you have any questions, Mr. Bowman?
I thought the max to the probation was 2 years.
No,
That's
it wasn't.
That's what they told me.
That's not part of any plea agreement, so no. Max probation you can get on a misdemeanor is 2 years. In circuit court, you potentially could get up to 5 years, but we're only giving you the 3. All right, that'll give you time to pay that off.
I think he's just
Mr.
looking at the
Jones?
max. I'm thinking he's looking at the max of the crime itself is 2 years, but probation, yeah, you're correct, Judge. 3 years up to 5.
Okay. All right, Mr.
Okay.
Jones, any instructions for Mr. Bowman?
He's gonna need to come to the office next Tuesday at 10 a.m. I know he doesn't live in the county, but we gotta have him come in one time so I can get everything done and transferred.
Do you understand that, Mr. Bowman?
Yes.
All right. Thank you. Thank you, Mr. Bowman.
Next Tuesday at what time?
10 a.m.
10 a.m.
Yeah.
Right. We can do it for Wednesday.
All right, that concludes our docket.